We have Professor Pandey chairing that session, and I'll very briefly introduce him. Professor Pandey is the K.L. Arora Chair Professor of Criminal Law at NLU Delhi. He is a renowned scholar in the area of criminal law, criminal procedural law, evidence law, criminology, etc. He has also worked with institutes of national and international repute in various capacities. No sir, absolutely not, just for the sake of record. I'll keep quiet. It's over to you. My apologies sir, it's over to you.
Good evening friends, I'm here to chair this session, but I have a unique distinction. Apart from Professor Ranbir Singh, I'm the only person who is speaking in the session without qualifying to be Professor Singh's student, MP Singh's student. I'm the only non-student of Professor MP Singh, and still speaking in the session. All other sessions were chaired either by Professor Singh's students or presentations were made by Professor Singh's students, including Justice Sikri. So you have had 8 presentations and 9th by Justice Sikri keynote address. 9 presentations on Prabhas's constitutionalism, that is constitution and we the people and free market. This is a tale of 2 journeys. Journeys of the Constitution and journeys of a professor teaching the constitutional law. 2 journeys. And I think journey of a professor teaching constitutional law is what is really nostalgic, and we have been together in the Faculty of Law. We have done good things in the Faculty of Law in Delhi University, and it is just a fortunate coincidence that we are again here together in NLUD, though I am here a week every month and not more. How long this will continue, I am not very sure. The journey of the journey of the Constitution is much more important than individuals. Journey of the Constitution, I feel, in the 65 years the Constitution has seen ups and downs. And I would have that quarrel with Prabhas. In the journey of the Constitution, in your second academic session, there were presentations more on the free market. Free market is not Professor Singh's darling, not Professor Singh's. We the people is Professor Singh's main concern. Therefore, there should have been, in all the presentations, we the people figuring out. I told Justice Sikri also in the morning that we the people walas, we are known to be the we the people walas. I told Professor Singh, I reminded him from avidya to vidya, from his writings on right to die and why it should not be a right in Delhi Law Review. All we shared the same kind of wavelength. Therefore, we the people should have got focus in all your presentations, and we are not interested the market remains free or market remains anti-dumping or dumping, and all that is not really our main concern. I see the presentations we have, 3 presentations here. One, a presentation on behalf of a professor from China, but the two presentations that will be made here, one by Dr. Parag Tripathi, who is, I think, a professor now, almost a professor in Jindal Global, and he has come after 6 hours lecture today. Today he did it 3 hours only, 4 hours. So, what Parag Tripathi Sahib is speaking, I would like to hear him. Anti-majoritarian function of the higher judiciary, a teasing conundrum. Now, majoritarianism is going to be a major problem area in India, more than free market economy, more than free market. Majoritarianism, I was listening yesterday to an interview by the culture minister. He was saying, he was giving a very different meaning of culture. And he was saying that we would like dominant dharma granths to be put in the curriculum, and that is our culture, and one-sided view of culture he was trying to propagate. And when it comes from the authority, ultimately India could difficult time when you become a Hindu state, and that is not very far away. There is no harm in it, but we have got to be alive to these problems. Majoritarianism is a problem that will have to be contained. Religious bias, yesterday there was a discussion on barriers, on bias, judicial decisions, and I say you cannot talk of no barriers and no bias when you have cases staring you on your face, cases like Rohini Salian's sort of recusal from the Malegaon case, and cases in which bail is being denied to accused just because he is Muslim. Therefore, this kind of scenario is unfolding, and we have to be ready to address it. Now, the real answer to this, I would briefly just touch upon, not force myself as chairperson here, is because there are two views that we think constitution or law is a philosophical or moral proposition. As against this, Horwitz said, the Anglo-American legal tradition is ahistorical. Why is it ahistorical? It sees things in decontextualized frame. So the moment you start seeing things in a historical unfolding, and why a certain law is passed after 2012 rape episode in Delhi in 3.5 months' time, because it has a history. The law which had been hanging fire for since 2007 was passed in 3.5 months, because it was a historical force that pushed the law to be passed. Therefore, I think the constitution and constitutional decisions and what is done to be the people of India will have great bearing if you understand the historical forces that are at work at the moment in our society, and you can quickly critique it and try to see it in advance. This will be the trajectory of we the people of India. This will be the trajectory of our fundamental rights. This will be the trajectory of I think I will come back. Before that, I will request Professor Parag Tripathi to make his presentation on a very exciting topic on anti-majoritarian function of the higher judiciary a teasing conundrum, Professor Parag Subhash.
Professor Ekti Singh, Professor Pandey, distinguished friends on the dais, friends and audience. Professor M.P. Singh has been one of our leading cutting-edge intellectuals, one of our towering members of the academia, and whose contribution from his mighty pen is still flowing at a very rapid pace. I actually, when I was teaching at the Jindal Global, this is my first year when I am doing a full-fledged course on constitutional litigation. On the anti-majoritarian aspect, I began with Professor M.P. Singh's latest article, which he wrote on the subject after the Nas 2 case. Actually, I strongly feel that one area where we have all let the academia down is the proportional or at least representation in the judiciary. And I am proud to say that here I at least recognize two outstanding professors, both of whom would have contributed so greatly from the highest bench. But then many judges are of that view too, but as I told one of them, that they normally come around to that view in respect of distinguished professors after they cross 65. That doesn't help. If you have to have a view of people who have not crossed 65, but be that as it may. Now I come, and of course, the two whom I straight away recognize in this regard is Professor M.P. Singh and my chair here, Professor Pandey. Now let me come to the subject. There's a huge discussion as part of judicial review as to the so-called anti-majoritarian function of the judiciary. What is this anti-majoritarian function? Very simply put, something which you can put in the famous guides which you have called the Idiot's Guide. So the Idiot's Guide to Anti-Majoritarianism will tell you that the principle is simple. The principle is that the court is not elected, it is therefore not responsible to the people. We are having a democracy. Laws are made by parliament or the legislature, which is elected and is answerable to the people. So when a law is made and a court strikes down that law, for whatever reason, A, B, C, not disclosing legislative competence, violation of fundamental rights, violation of any other provision of the Constitution, what the court is doing is anti-majoritarian or counter-majoritarian. It is opposing and acting diametrically opposite to the will of the people. I will deal with the Nas Foundation and the reverse anti-majoritarianism there. But first let me briefly delve on this because I have all of 20 minutes, I've spent already 3, so 17 more to go. The concept of anti-majoritarianism started with a seminal lecture of Professor James Bradley Thayer at the Harvard Law School. He wrote in the Harvard Law Review way back in 1893, where he said that net what anti-majoritarian principle requires is that, of course, that is a province of the judiciary, because if a law is contrary to the Constitution, the judiciary has to strike it down. But it must do when it's a clear mistake by the legislature and there is no other option. That is the famous schema, there is no other option or no other alternative. Alexander Bickel later on in 1962 said that this is a counter-majoritarian force, and court declaring unconstitutional a legislative act of an elected executive is the core of that function. In between, Felix Frankfurter, who was one of the students taught by Professor Thayer, had written in 1937 that this is the single most seminal thought for the last several years in the field of constitutional law. How does this principle work in India? There is an interesting perspective given in an article by my father, but that's not the reason why I'm citing it. Then he said, look at the Indian experience. 1950 to about 1964, 65 and then 67 Golaknath. Initially the court said yes, we will defer to the constitutional amendments, and then the court in Golaknath said law and constitution is the same, you can strike down the amendment to the constitution by the same principle by which you strike down the law, that is Article 15. Therefore, the consistent losers in the political process, that is the groups which said don't go for land reforms, don't go for bank nationalization. These are fundamental issues of socio-economic governance. These are not issues like our chair was saying a minute back, rights of minorities, rights of insular non-religious minority, as was the case in NAS. They may and do stand on a different footing. These are governance issues of how do you want to have your socio-economic rights in place. So consistent losers there in the political arena would come to court, and Bela Banerjee and that series of lines of cases would get an order saying these acts violate fundamental right, compensation has to be just, fair, equitable, etc. Now if you look at the Indian experience, there is a much criticized judgment in ADM Jabal. The view is that the other four justices, like Justice Khanna, should have said, this is draconian, we strike it down, you cannot arrest people without even writing their names. It is of course draconian. But look at what has happened there. What has happened there is a reverse Thayer doctrine. The Supreme Court did not interfere, it said hands off. So who interfered? The people interfered. When did they interfere? At the next election. What did they do? They threw out the government which had brought that draconian play, that draconian arrangement of emergency. What was the result? The result was that by withholding the counter-majoritarian function, which is court's right and obligation as well, the court provided a whole amount of political maturity. Because till then, till 1985, there was only, till 1975 or 77, there was only one government. That was the Congress. After 75, you realize that Congress is not the beginning and end of it all. There can be other governments also. So there was a process of political maturity, which I call the reverse Thayer doctrine. That is, not only should you hold back your counter-majoritarian exercise of power, unless you feel that it is a make or break case. But if you hold it back, it has a great impact on the political learning of the democratic system. Now, there have been some interesting later developments as well in the concept of counter-majoritarianism in US, in England, and indeed by two Israeli scholars. The interesting concept which arises out of a couple of articles, one by Jeremy Waldron, who's a professor at the NYU, and Stephen Macedo, is that yes, take the American Supreme Court, they do act in a counter-majoritarian manner, but they are what Mark Tushnet says, weakly counter-majoritarian. Now, what does weakly counter-majoritarian mean? Why weak and not strong? Because it says that how does a court get its legitimacy? Every institution has to have a source of legitimacy. You can't survive without legitimacy, except unless, of course, you're a lawyer. All other institutions need legitimacy. So where do you get this from? The court gets it from its acceptance. So people have to accept that yes, these guys in black robes do a counter-majoritarian thing, but I think I'm okay with it. So maybe this time they've gone wrong, but by and large they are okay. So the court is looking at its legitimizing constituent. So it is not unaccountable. The court also normally has judges who have gone through a rigorous life as a lawyer and a judge. So they know that you can't have this spirit of a raiding knight in shining armor that I'm going to fix everything tomorrow or today. So there is a sense of the whole judicial life, a lawyer's life, that you realize that there are limits, there are institutional issues here. These are the accountabilities of court. So Macedo and Waldron and others point out that look at the American Supreme Court. In 1958, they came up with separate the Board versus Brown of Brown versus Board of Education. In that judgment, they stopped there on desegregation. They did not go to women's rights, rights of gay people, marriage of gay people. Why? Because these three elements were way beyond the majoritarian view. So if you are weakly anti-majoritarian, you won't do your all reforms at one go. Why? Because if you do, you will lose your accountability base, the legitimacy base gets eroded. Take an instant case in India, the Upahar case. The court went and said some 30 crores, 40 crores you pay and you go free. Look at the reaction. It hit hard the legitimacy base of the court. How can the court do this? Now consider 5 more such judgments and then the legitimacy goes. Therefore, though at one level they are unaccountable to, there is no question of re-election to office, but there is, however, an accountability. Accountability to rigorous standards of law and its interpretation, where they are accountable to scholars like Professor M.P. Singh and my chair here, on and off lesser scholars like me as well. Then accountability to people. Are these guys doing the right thing? By and large, yes, or not at all. So, though there is anti-majoritarianism at first blush, but if you look deeper into it, it is in a sense an accountable anti-majoritarianism, or at least not wholly unaccountable anti-majoritarianism. We then have, as I said, I told you about the weaker judicial review. There are 2 or 3 aspects of how the courts functions as an anti-majoritarian system or an institution. Friedman, who is one of the professors at the NYU in the US, says, one is, but that's a more of an American-centric aspect, what he calls a representation reinforcement, because America had a lot of electoral reform cases where they found that one person, one vote was not working. So they structured it in such a way that you get back to one person, one vote. So though you are exercising anti-majoritarianism, striking down a law, but you are doing it to reinforce the representative character of a democracy. If you look deeply, you find we did it in India too. In India, the right to information revolution led to the requirement that the people who are contesting elections must disclose. Now the Indian law didn't go that far. But this was again representation reinforcement, because you are reinforcing the roots of democracy. If I have to decide whether I vote for A or B, I must know who is A and who is B. So I am not taking away, as it were, from the system, but making the system more representation oriented. The other, of course, is the originalism or the purist doctrine that constitution is what it was when it was created. Originalism often is a mask for putting forth a view which you think is correct and then giving it, as it were, a categorization that this is originalism. As opposed to it is living constitutionalism, which says just the opposite. That look, when the constitution was made, there was a certain scenario which existed. We have moved on. So we have to interpret the constitution in light of the scenario which is there today, not unmindful of the constitutional principles, but not being unnecessarily confined or cabined by constitution as it was written. Now, let's come back to the Nas Foundation case. That is important for 2 reasons. One, the normal reaction to the Nas Foundation case was one of trenchant criticism. What I mean is Nas Foundation 2, the Supreme Court judgment, which said that look, the High Court judgment is wrong, even though the Union of India through the then Attorney General, the late Ghulam Mahanbati said we are not opposing the judgment, we are supporting it, we are here to assist you. The court said, nonetheless, I proceed and hold, I have to see the law as I find it. I find nothing infirm in 377. Parliament wants to change it, they can of course change it, no difficulty. That's equally a plausible law. But it's not in our province to do it. Now, here there is a very, Professor Singh has very rightly said, his article begins with a very nice quotation of Justice Learned Hand, which says that don't rely over much on constitution and on courts. Why? Because there has to be a spirit of liberty in the hearts of men and women. When it is there, you don't need them. If it is not there, they can't help you. It's extremely well. So Professor Singh says that look, this was a case where the court has really done no wrong. It's done the only right thing which was available. Because the court says 377 is there, it has stood the test of time, Parliament is free to do what it does. But look at it a little differently. What was Nas 1 the High Court doing? High Court reads down 377. Now this is a classic anti-majoritarian or counter-majoritarian decision. Why is it a classic anti-majoritarian? The classic is of course striking it down. Reading down comes next in the list. So you have read down 377 to say that consensual sex with people of the same sex or sexual orientation at the age where you can give consent doesn't fall within 377. So this is, we can say, mildly anti-majoritarian. What does the Supreme Court do? Now here is a classic case of what I call reverse counter-majoritarianism. Why reverse counter-majoritarianism? I told you about reverse Theorin doctrine in India and ADM Jabalpur and thereafter. Why reverse? Because it was clear that the government, which is supposed to reflect the majority in parliament, and that's why government is there, takes a stand which we presume would be a stand in keeping with the majoritarian view, that we are okay with the judgment. This reading down is okay by us. The reaction of the glitterati and the chatterati, and also I think of large number of average people, was that this is okay. So though the law was what it was because of originalism, because 1862 it has stood the test of time, the public sentiment and mood was with the Delhi High Court judgment. So that was really the majoritarian principle. So why Supreme Court got this huge flag in an otherwise, according to me, technically a correct judgment, was that it was really doing reverse counter-majoritarianism. By not striking down the law, it was going against the desires and aspirations of a larger number of people. There were of course various religious groups, both Hindus, Muslims, Christians, who said these are against our religious ethics. But as a citizen I feel there is no doubt that the reflection, if you had a referendum today, the result may be well 30 may say we have no option, we have no view. But the majority would still say amongst those who vote that yes, why not? I mean, this may be a thing I have no interest in, but if you want to do, well, go and enjoy. We are not bothered. Our constitution is wide enough to take it. So the part of the reason of the flag was that the court for the first time fell into the trap of reverse counter-majoritarianism. It ostensibly eschewed counter-majoritarianism by not reading down the act or striking down the section, but in effect and substance, it really acted in a counter-majoritarian way because it went ahead and reversed the judgment which seemed to have public sympathy. So, where does that leave us with? What it leaves us with is three things. One, it is after all, as Dworkin says, the only function of court at times to be counter-majoritarian. Because it's like doing a surgery. When you've got to do a surgery, you've got to do a surgery. You can't say, I won't do the surgery. So counter-majoritarian activity or jurisdiction of the court is a necessity or a compulsion at times. Of course, it should be exercised sparingly, no doubt about it. But it is the function, chosen function of the court, because somebody has to do it. However, when court trenches in counter-majoritarian areas, as in the American court, which first did Brown versus Board of Education, then it did about women's rights, then it said, all right, you cannot criminalize gay action, and finally Roberts Court, this term said that you can have gay marriages, you can't criminalize or say that gay marriages are illegal. So the courts are very conscious of their legitimacy base and move just a little ahead of it at times, so that they know that this much our legitimacy base can take, and this is the movement which the thought process or society is taking. So, really speaking, therefore, there is a clear tension between the function of the court and, of course, of parliament, which is a tension which is dehors the persona of the court and of the parliament. But that function is best resolved so long as the court and the parliament recognize that there is nothing called an unaccountable institution in the true sense in a democracy. There are, even court is accountable, is subject to stringent criticism, is subject to trenchant criticism In US even more. In US when they had the New Deal legislation, they had books like the 9 Super Idiots. It's all right. Their freedom of speech permits that. So there is an element of accountability, and that element of accountability we must feed into our equation and calculus when we deal with the exercise of counter-majoritarian principle by the courts in this country. Thank you very much.